Now, the law gives a spouse a security of occupancy of family land. This means that every spouse has a right to access, utilize, and live on family land. As long as land qualifies as family land, then a wife or husband has a right to access, live, and utilize that land. I can't emphasize this more than I have emphasized it. So the security of occupancy that is granted to spouses is such that you can't wish away your spouse from family land. And the law requires in very express terms that family land shall not be mortgaged, given away into divorce, sold without the consent of the spouse. That consent takes a prescribed form within the law, and it must be voluntary. Now, the law gives an express right to a spouse to deny or give consent for transactions touching family land. So a spouse has a right to give or to deny consent for transactions touching that land. So if the consent is not given for a transaction on that land, there is a consequence if a transaction is actually done on that land. However, it is also the requirement of the law that consent for dealing with family land should not be unreasonably denied by the spouse. So what happens if the spouse refuses to give consent for a transaction on family land? In that case, the law gives the other spouse the right to move court to dispense with the consent after the other spouse has failed to show cause why the requirement of consent should not be dispensed with. Therefore, if you want to deal with family land and the spouse denies you consent, it's not the end. Not all hope is lost. If you feel that the consent is being unreasonably denied by your spouse, you are free to consult your lawyer, and if the circumstances are satisfactory, your lawyer can move court to enjoin your spouse to show cause why the requirement of consent should not be dispensed with. If the other spouse cannot justify their denial of the spousal consent to transact on family land, then the court will dispense with the requirement of consent, and in that case, the transaction will go on without the consent of the spouse. Without a court order, any dealing with family land without the consent of the spouse is legally fatal. Now, that consent which I have been talking about must be given by the spouse before the transaction. The law is very, very clear, says the prior consent of the spouse. Prior consent of the spouse. So you do not sell the land and then seek the consent or seek ratification. If it is shown that the consent was not given before the transaction is void from the beginning to the end. It is a dead on arrival and you cannot add it to anything. So if a transaction on family land lacks the requisite spousal consent, that transaction is null and void. Therefore, if out there family land, or land which qualifies as family land, was transacted by one of the spouses without the other spouse's consent, then the innocent spouse has a right to move court for the cancellation of that, for the annulment of that transaction and the recovery of that land. If legally the land is not registered to one of the spouses, but it qualifies as family land within the meaning of the law invites the other spouse in whose name the land is not registered to lodge a caveat indicating that that land is subject to the requirement of spousal consent. Now, not lodging that caveat is not fatal, but if there is that caveat, it even strengthens your position as a spouse if that land is dealt with without your consent. So my advice is that whenever land qualifies as family land, then the spouse in whose name that land is not does himself or herself good to lodge a caveat on that land, indicating clearly that that land is subject to the requirement of spousal consent for any transaction to be sustained on that land. Lodging a caveat is desirable and it strengthens your position if it turns out that the transaction is done on that land, that family land, without your consent. So, if you consider land to be family land, you need to take the facts surrounding that land to your lawyer. And after your lawyer has made a determination that that land is indeed family land, the correct thing to do is to proceed and lodge a caveat on that land, indicating clearly that it is subject to the requirement of spousal consent before any transaction can be had on it. Now, that caveat that I'm talking about, once lodged, cannot be lapsed easily. It's only a court of law that can order lifting of that caveat. So it remains on the land, protects the spouse's interest in it, and if anyone wishes that that caveat be removed, he must move court to make a pronouncement on the same. Now, so what happens if a transaction is done on family land without spousal consent? The law is such that if a transaction on family land is concluded without the requisite spousal consent, then that transaction is null and void. The law goes ahead to say that if the transaction is entered bona fide, meaning if, say, a mortgage is concluded with a bank, or if a sale is concluded with a buyer without the requisite consent, the mortgage or the sale is null and void. There is no way around it. That said, I believe this has been a very helpful session, and I thank you for being good listeners. Do not forget to subscribe to this channel, and may God bless you.